Good morning, everyone. I'm going to now go through Wayfarer's Dalbert motion, trying to basically exclude testimony and opinions of Lively's proposed experts. Unlike Lively, they put all of those in one document. It's 104 pages long. But what they have done is they've actually kind of, gone section to section. So one section is about Jennifer Freyd, the DARVO expert, and then they move on to the next section, and they've broken up really nicely, actually. So what I'm going to do is I'm going to do a video for each expert. I think that's going to be the best way of doing it, because it's too long to go through in one sitting. This video would be about 3-4 hours long, but it's the report is kind of nicely nicely written to kind of facilitate just doing a video on each expert without kind of they're not all mixed up, and there's an opinion about this expert and an opinion about this expert. So that's what I'm going to do. The first expert is going to be Jennifer Freyd. Now, I will say I've already gone through her report. I did it back in January when it was unsealed. It is oh my god, it is absolute wild. It's like a roller coaster ride. It's startling that Lively very much cherry picked evidence, which in her opinion made Wayfarer look awful. Didn't include anything that might undermine what she's saying, though, like her PGA letter, or some of the messages between her and Josh Greenstein, or her and Taylor Swift. The expert has got, I don't know, she's just an educational theorist, really. She's not like a clinician or anything. So she's weighing in all these opinions about Lively being suffering from betrayal blindness, and Lively having a high risk of PTSD because Justin Baldoni called her character's wardrobe sexy, which was the most stupid thing I've ever heard in my life. And basically, she goes through all of these things, and then right at the end, she goes, I can't remember the exact wording, but it was like, yeah, so in my opinion, everything that Lively has experienced is, is DARVO. Everything Wayfarer have ever said or done is DARVO. And it's like, how have you got to that? How have you got to that? It's crazy. So yeah, I'll put a link for that video because it's just it's entertaining. How I would be surprised if it's admissible, because it's so problematic. But this is yeah. When I read it, I was like, oh my god, this is Lively's Dr. Spiegel. But let's go through this. Let's go through this. Okay. Pursuant to Dalbert and Federal Rules of Evidence 702, 401, and 403, defendants move to exclude the testimony and opinions of plaintiffs' proposed experts Jennifer Freyd, Dina Maislin, Aaron Carlotta, Ashley Humphreys, Jeffrey Kinrick, and Michael Robbins, Michael Sipple, and Richard Marks. Legal standard. Oh, my voice is not great today. Sorry about that. Lively has the burden of proving by preponderance of the evidence that her expert's testimony is based on sufficient facts or data, is the product of reliable principles and methods, reflects a reliable application of the principles and methods to the facts of the case, and will help the trier of fact. The court must take a hard look at the testimony and undertake a rigorous examination of each of Rule 702's requirements, because an expert's methodology must be reliable every step of the way. In re In this way, the court acts as a gatekeeper against unreliable and irrelevant expert opinions. Rule 702 was amended in 2023 to re-emphasize this judicial role and to counter the practice of some courts to treat questions about an expert's basis or methodology as questions of weight and not admissibility. In addition to reliability, Lively has the burden of showing not only that her expert's testimony meets the bare relevance of threshold of Rule 401, but that the expert's specialized knowledge is on a subject matter beyond the ken of the average juror and will help the trier of fact. Because expert evidence can be both powerful and quite misleading, the district court exercises more control over experts than over lay witnesses under Rule 403, which plays a uniquely important role in assessing expert testimony. Okay, so argument. The court should exclude the testimony of Jennifer Freyd. Lively offers Jennifer Freyd, PhD, a trauma researcher, to opine that Lively suffered betrayal trauma and institutional betrayal, and is therefore at extremely high risk of such symptoms as suicidal ideation, hallucination, and self-harm, among others. I mean, she can't offer that because she withdrew her own intentional and negligent emotional distress claims. She can't do that. She was going to testify to garden variety emotional distress with just recipient witnesses. That'd be family, friends, People said, oh, yeah, it really upset her. Lively offers Jennifer Freyd, PhD, a trauma researcher, to opine that Lively suffered betrayal trauma, institutional betrayal, and is therefore an extremely high risk of such symptoms as suicidal ideation, hallucination, and self-harm, among others. And I know I've just read that already, but I just needed to reread it again to process it. Such testimony is plainly inadmissible. First, Lively expressly waived the right, to offer expert mental health testimony. She did so when defendants requested discovery to probe her mental condition. In refusing such discovery, she made clear that she would offer no more than evidence of garden variety emotional damages and would rely solely on recipient witnesses. Second, even absent this express waiver, Freyd's opinion formed without interviewing her. Reviewing her medical records, conducting clinical tests, or speaking with her medical providers is almost pure ipse dixit and palpably unreliable. Yeah, because her report did not reference any medical records or that she had interviewed Lively. Like in the list of things that Jennifer Freyd used to form her opinions, and that went into her report. Anything that was from Lively's medical records or any reference to actually speaking to Lively, doing any medical exam tests on Lively, there was no reference to any of that at all. Also, ipse dixit is just it's Latin. It just means basically unreliable statement. Third, Freyd essentially offers a closing argument in support of Lively based on her own interpretation of documents and testimony. Her theory is that defendant's conduct fits the pattern of DARVO, a term Freyd herself invented, but how perpetrators typically retaliate against their victims. None of this is helpful or reliable and will only confuse the jury. It also unfairly prejudices defendants by bringing in a backdrop of unrelated conduct by others, none of which is at issue here. Freyd's testimony should be excluded in its entirety. Freyd is an academic researcher in the field of trauma response, but not a therapist or licensed clinician. Her opinions center on the theories she began developing in the 1990s: betrayal trauma, institutional betrayal, and DARVO, which stands for deny, attack, and reverse victim offender. In reaching her opinions, she did not conduct a clinical interview of Lively or perform any tests, nor did she review Lively's medical records or speak with her medical providers. Instead, she has relied exclusively on the deposition testimony, pleadings, and other litigation materials provided by Lively's counsel. Okay. And it's important for, oh, yeah, because with the Depp case, Spiegel tried to tell the jury that he had diagnosed Johnny Depp with narcissistic personality disorder. And when he was questioned further by Wayne Dennison, who is, for me, he was the unsung hero of that entire trial. Like, Ben Chu was great. Camille Vasquez was an absolute queen. Wayne Dennison, though, that guy and how he handled witness experts is absolutely legendary. And you need that with the witnesses. Because they actually, quite often, the jury will hold them to a higher standard than ordinary witnesses. So you need someone who can handle the expert witnesses to expose their weaknesses, their flaws. And he did that masterfully, especially with Dr. Spiegel, when he went into this diagnosis, he got Dr. Spiegel to concede he'd never interviewed or met Johnny Depp, and all of his diagnosis, his entire diagnosis, was based on watching Pirates of the Caribbean and Willy Wonka. He'd never reviewed Johnny Depp or reviewed his medical records either, because what happened in that case was Amber Heard was subjected to a court-ordered examination, which included her medical records, by Dr. Shannon Curry, because she put mental health at issue. And when Shannon Curry diagnosed Amber Heard with borderline personality disorder and histrionic personality disorder. And those were valid diagnoses because they'd gone through the proper process. When they tried to do the same with Johnny Depp, it became clear Johnny Depp had never put his mental health at issue. So when Amber Heard tried to get a court-ordered examination of him, the court said no. So they brought in an expert who had never met him, never spoken to him, and just watched his films. And he tried to offer a diagnosis based on that, and it was, shut down quite quickly. But that's kind of what Lively's doing here, right? She's trying to offer up a diagnosis of herself, but she didn't want to put her mental health at issue in terms of, allowing Wayfarer discovery, allowing them to speak to her medical providers, obtain her medical record, or have a court-appointed, examination. So Lively said, no, I'm not doing all that. But then now she's trying to, backdoor in this expert who's not even a licensed clinician to offer opinions based on theories. And Wayfarer having none of it. Rightly so. Absolutely rightly so. Okay, we keep going. Freyd's central opinion is that Lively suffered betrayal trauma and institutional betrayal, and that as a result, Lively is at increased risk of certain symptoms of distress, betrayal blindness, re-victimization, depression and suicidal ideation, anxiety, shame, PTSD, disassociation, physical illness, hallucinations, self-harm, and problematic substance abuse. And I will say this, right? I'm diagnosed with complex PTSD, right? I've made no secret of that. I've talked very openly about it. That comes after nearly a decade of abuse and controlling coercive behavior from my ex-husband. It includes marital rape. It includes a whole host of things, which I've been very honest about. I'm very open about, it's a big factor for my reason why I followed this case, why that film was important. And I was diagnosed with complex PTSD, and my life is an absolute nightmare. And I'm sure a lot of I'm saying this as a layperson now, right? From the perspective of what is a juror, the average juror, likely to think reading this? Yeah. Are they like to think? I mean, her allegations include he called my outfit sexy, or she had to film a scene where her hip was on show. This is the same woman who once filmed an entire film in a bikini. Right? Go and watch the In the Shallows. You know, was there an intimacy coordinator on set for that film? Was she traumatized? Did she sue anyone? You know, people, and the same with her. You know, her onesie that was unzipped. I'm sure Wayfarer will bring in photos where Lively walks around sometimes to premieres with what looks like a jacket on and nothing underneath it, or incredibly low cut dresses and tops by choice. But then she'll say, "Oh my god, you know, my onesie was unzipped, or it was zipped, you know, low, and you could see my bra." And this is all supposed to have caused her PTSD because, you know, even if he did, and there's no evidence that he did, Justin Baldoni remarked on it that it was a nice dress. And no normal person, normal, logical, clear thinking person, and don't have to be any expert in any field for this. Most people will sit and go, how can you even compare that and say that is traumatic, causing you to feel suicidal ideation, causing you to want, you know, to be at high risk of self-harm? It's not even comparable to, you know, most people's when most people talk about sexual harassment in the workplace, they are envisaging, you know, groping, you know, a man breathing into a woman's neck, like really close, standing really close and breathing, and or, you know, being held back in your job because you won't do something sexual. You know, it's just it's just stupid what she's claiming here, and it really pisses me off. I know it pisses everyone off, but I can't believe we are here, all multi-million-pound lawsuit, all for this, you know, and a kangaroo court, quote unquote, expert who is just going to sit there and dog whistle. Okay. Lively's risk associated with the above symptoms to be extremely high. Yeah, I don't think so. In addition to this not quite diagnosis, Freyd would opine on Lively's supposed low-level betrayal blindness, whereby Lively continued to give Baldoni the benefit of the doubt as he continued to make inappropriate remarks and violate Lively's boundaries. In Freyd's opinion, Lively oscillated between awareness of Baldoni's and Wayfarer's toxic behavior and an understandable desire to hope for the best. Finally, Freyd would offer various narrative opinions, repackaging Lively's allegations and theory of the case under the guise of an opinion on DARVO. For example, Freyd would testify to her opinion that Lively experienced a pattern of retaliation and intentional reputation damage directed at her. She would offer her opinion that Baldoni's text to his friends downplayed Lively's concerns while at the same time acknowledging that she was accusing him of sexual harassment. She would offer her opinion that Mr. Baldoni and Mr. Heath continued to cover up Lively's experience at a dinner with author Colleen Hoover. She would give her opinion that Heath offered a performative acknowledgement of the woman's experiences, recognizing them only to deny their validity and reassert his version of events. She would explain her opinion that each time Miss Lively raised a concern, Wayfarer minimized her concerns and attacked her instead. She would give her opinion that Wayfarer engaged in further attack and RVO by causing the online smear campaign to commence with attack and RVO themes. This goes on and is all set up for the punchline. In my opinion, Wayfarer's entire defense in these court proceedings is a classic example of DARVO. So Wayfarer literally coming to court to defend themselves is also DARVO. That is what this expert said. So men who are accused of such things are no longer entitled to justice, due process. If they make any attempt to defend themselves from allegations, without the allegations themselves being proven, that is also in and of itself DARVO, according to this expert. That is an absolute extreme and wild world to live in. And I said this in one of the amicus briefs as well, where they were like, well, even defending yourself is, an amicus brief even said the same thing too, just the mere defending of yourself, or, saying that the quote unquote victim, I've got air quotes going here, is lying, is also like further abuse. I don't know why these experts do this, because everyone is entitled to deny allegations that are made about them, and everyone is entitled to defend themselves. I'm astonished that there are experts who openly believe that no one, this is not just a man thing, this could work in the opposite direction. This could be a man accusing a woman of sexual harassment, but the person who's been accused, we have experts now testifying, saying that we're at a point where they should not be allowed to defend themselves, because that is also part of the abuse. And that, in my opinion, is absolute bullshit. It is. When I made my allegations against my ex-husband, he had a right to try to defend himself, to bring any evidence that supported his defense. And that is right. I may not have liked it. Most people don't like it. He didn't have anything, but that is not the point. It is his civil right to do that, because we should operate in a world where people are innocent until they are proven guilty. And I know that's a criminal standard. This is not a criminal case, but I think I feel like, that should apply here, because the allegations are of potentially a criminal nature. So the fact that this is a civil case, it doesn't matter to me, right? What you're accusing people of is in and of itself a criminal nature, and that can do some serious damage. And I don't like the suggestion of a world where we don't allow people to defend themselves. Okay. Lively has waived the right to offer expert testimony in support of her emotional damages. Yes. Freyd's testimony regarding betrayal, trauma, and institutional betrayal must be excluded because Lively expressly waived all but garden variety emotional damages and forswore expert testimony to support those damages. To moot defendant's motion to compel access to Lively's medical records, Lively agreed to the dismissal of her claims for intentional and negligent emotional distress. Lively subsequently told the court that she waived the right to offer testimony or evidence of the identity, records, treatment, or diagnosis of or her medical or her healthcare providers related to such emotional distress, but may offer evidence of garden variety emotional distress damages, including testimony of herself and percipient corroborating witnesses. The court so ordered Lively's letter, ruling that Lively was precluded from offering medical evidence of emotional distress, but could offer violence. Yes, she offers violence all the time, but could offer evidence of garden variety emotional distress. These representations and rulings are crystal clear and bar Lively from offering Freyd's opinions regarding the trauma Lively supposedly suffered and a heightened risk for significant physical and mental health impacts. Had Lively reserved and not waived the right to an expert mental health testimony, defendants would have been entitled to appropriate discovery, including relevant medical and psychological records, and an independent medical examination conducted by an appropriate clinical professional. Exactly. Having cut off such avenues of discovery, Lively is now precluded from offering evidence on the same topic. Yeah. This is perfectly written. I love this. Freyd's opinions regarding Lively's emotional damages are inadmissible under Rule 702. Freyd's opinions on emotional damages are also inadmissible because, even assuming that Freyd's theories are reliable in general, Freyd has not applied these theories reliably in forming her opinions as to the particular matter at issue in this case. An expert must deploy in the courtroom the same level of intellectual rigor that characterizes the practice of an expert in the relevant field outside the litigation context. Freyd plainly has not done so here. It is generally accepted practice in the field of psychiatry for a diagnosis to be made based on the examination of the individual being assessed. Accordingly, court decisions involving psychological or psychiatric expert testimony typically recite that the testifying expert has personally interacted with the patient. For example, in Cat, the psychologist based her opinion on 6 hours of face-to-face interviews, a study of plaintiff's medical records and life history, and a clinical test to determine causality. In Ross, the psychologist's opinion was based on a clinical interview and observation of the plaintiff, review self-report measures, and review of medical records. In contrast, the opinions of psychological experts who render their opinions without conducting a clinical interview are generally excluded. In Chatat, I probably got that wrong. Sorry. For example, the court excluded a psychiatrist's opinion that was based only on a review of his medical records, deposition testimony, and other documents. Similarly, in Mazzocchi, the court excluded a psychiatrist's opinion that plaintiff's actions were consistent with textbook descriptors of bipolar disorder, where the opinion was not a diagnosis and was not based on an in-person examination of plaintiff or a review of her medical records. Even psychologists who do interview their patients may be barred from giving an opinion if their evaluation is insufficiently thorough. For example, if they do not review relevant medical records, conduct appropriate tests, or follow up with the patient's medical providers. In El Ansari, the court excluded the plaintiff's expert psychologist's diagnosis as unreliable, even where the psychologist conducted a clinical interview, because the psychologist never reviewed any of the plaintiff's medical records or made any effort to contact her medical providers. In Matthews, the court excluded the plaintiff's psychological expert who had interviewed the plaintiff for 3 hours over the course of 4 meetings, where the psychologist did not review the plaintiff's medical records or perform additional psychological testing. In Manafo, the court excluded a psychiatrist who conducted only a sparse examination, relied entirely on the plaintiff's own statements, and did not exhibit the rigorous application of scientific principles. Freyd, who is not a therapist or licensed clinician, has not interviewed Lively, reviewed her medical records, conducted tests, spoken with her medical providers, or ultimately rendered a diagnosis. Rather, she has reviewed deposition transcripts, pleadings, and other litigation documents, presumably selected by counsel, and based on these documents is willing to opine that Lively is at increased risk of severe trauma-related symptoms, all because of defendant's alleged betrayal. She has done no follow-up and apparently has not probed Lively's claims in any way. And Freyd's bar for betrayal does not appear to be particularly high. She states that a person would be categorized as having experienced institutional betrayal if they checked just one item on a 12-item checklist. This is not the kind of thorough, neutral, and scientific evaluation that a psychologist would undertake if seeking to diagnose a patient outside the litigation setting. Bang on. Absolutely right. Freyd's other opinions are inadmissible under Rules 702 and 403. Freyd should not be allowed to testify about Lively's supposed low-level betrayal blindness. Freyd's opinion about Lively's supposed low-level betrayal blindness is also unreliable and therefore inadmissible. Freyd's opinion falls far short of a diagnosis and was arrived at without using any of the tools, clinical interview, tests, review of medical records that would be used by a psychologist doing actual clinical work. Freyd's testimony about betrayal blindness is also not a fit for the case. Freyd describes betrayal blindness as the unawareness, not knowing, and forgetting of betrayal traumas. But this is not a case involving the suppression of a painful memory. Rather, Freyd would testify that Lively tried to see the best in Wayfarer and Mr. Baldoni, that Lively felt a responsibility to keep the production on track for the benefit of all cast and crew, and that Lively oscillated between awareness of Mr. Baldoni and Wayfarer's toxic behaviour and an understandable desire to hope for the best. That has nothing to do with betrayal blindness, as Freyd describes it. In any event, these issues are completely irrelevant now that Lively's sexual harassment claims have all been dismissed. Moreover, to the extent that low-level betrayal blindness is just hoping for the best, it is well within the ken of the ordinary juror and therefore not a proper subject of expert opinion. Lively can, of course, testify to these points, and the jury will or will not believe her. But the jury is more than capable of reaching its own conclusions without ventriloquism or commentary from an expert, especially one who has never even evaluated Lively. Oh, this is such a good motion. Freyd should not be allowed to testify as a summation witness. So when we say summation witness, that's kind of like almost like a summing up type thing. Like, after other experts come on, maybe bring this one on then to kind of just round up what everyone has said, bring it all together. Lively apparently also plans to use Freyd as a summation witness, describing and commenting on the evidence while showing by her presence on the stand that an expert believes and supports Lively's case. Such testimony should not be permitted. A party may not use expert testimony to provide itself with an additional summation by having the expert interpret the evidence. By echoing the narrative of the in-court testimony without offering a true opinion, such testimony may improperly bolster the account given by fact witnesses. Yeah. Here, Freyd will offer a variety of narrative opinions, including that Lively experienced a pattern of retaliation and intentional reputation damage, that Wayfarer minimized her concerns and attacked her, that Lively was victimized repeatedly, and even that Wayfarer's entire defense in these court proceedings is a classic example of DARVO. Now, that's terrifying. If Judge Lyman lets this sit and she says all that and Wayfarer loses the case, Wayfarer have grounds to appeal and should. None of this is proper expert opinion. Rather, it is a regurgitation of the plaintiff's case uttered through the mouth of an expert. Acting simply as a narrator of the facts does not convey opinions based on an expert's knowledge and expertise. Of course, Lively may argue that some of these points in summation, if they have evidentiary support, but she should not be permitted to weaponize the added aura or reliability that necessarily surrounds expert testimony to tell her story through a witness whose only knowledge of the case comes through hearsay and who is using no real expert to form her opinions. Such testimony is inadmissible under Rule 702 and under Rule 403, which has a uniquely important role in the court's scrutiny of expert testimony, given the unique weight such evidence may have in a jury's deliberations. Freyd should not be allowed to testify about DARVO. Freyd's proposed opinions about DARVO are also not helpful, not necessary, and will only confuse the jury. The question for the jury is whether defendants retaliated against Lively in a manner cognizable under the law, not whether their behaviour constitutes DARVO. Freyd's testimony on DARVO is neither relevant nor a subject on which the jury requires assistance. Moreover, experts must not be permitted to usurp either the role of the trial judge in instructing the jury as to the applicable law, or the role of the jury in applying that law to the facts before it. The court will instruct the jury on the elements of retaliation, and Freyd's theorizing about DARVO will only lead to unnecessary confusion. The opinions on DARVO are also an attempt to have a supposed expert on retaliation look at the facts and opine, tell the jury what result to reach. Yes, that's exactly what's happening here. The testimony is inadmissible under both Rule 702 and Rule 403. Freyd's opinions should be excluded in their entirety, and she should not be permitted to testify at trial. Okay. I'm going to stop there because we're going on to Dina Maislin, another expert. I'm really, really loving what Wayfarer have put together there for Jennifer Freyd. Incredibly strong arguments. I cannot believe that it's more tactics and unethical tactics that Lively's counsel are attempting here, and it is getting frustrating. And I've said this from day one. If you believe in your case and you believe in the evidence, and the evidence is sufficiently strong that it speaks for itself, you do not need to start, going out of your way to perform underhand litigation tactics. You should not need to do that. People who do that don't have a case or don't believe in their case. And that's my opinion. All right. So I'm going to stop here. I'm going to go and move on to Dina Maislin. But I hope you found this really interesting. I will put a link again to my reading of Jennifer Freyd's report, which was just, basically pages and pages of, fairy tales and just nonsense. It was absolute nonsense. Let me know in the comments though what you think.